interestingly, when the measures adopted by the Security Council against Iran in 2005 were taken, there was no mention of the UN Participation Act. So the point I'm making is that the legal basis is plainly US domestic legislation. Now, the problem with using the Emergency Act, the IEEPA, is that the US has to declare a state of emergency in order, a declaration of national emergency. And I quote, an unusual and extraordinary threat to the national security, foreign policy, or economy of the United States. So this means we are in a constant state of emergency, which means, of course, that they cannot or can with difficulty be challenged before domestic courts, because obviously the executive will always rely on its emergency, on this emergency situation, plus the fact that many of the documents and evidence are kept confidential. Now, as far as their content is concerned, so we've spoken of the legal basis, as far as the content is concerned, that's not identical either to that decreed by the Security Council resolutions on Iran. As you know, the Council adopted certain resolutions from 2006 to 2010, which imposed targeted sanctions on Iran for its failures to comply with the International Atomic Energy Agency requirements and its continuing uranium enrichment activities. Now, as I said, I have no time to go into the details, but one thing that is extremely clear is that the Security Council was avoiding comprehensive sanctions. As I will come back to later on, comprehensive sanctions had been extremely discredited after the sanctions against Iraq. So they impose certain targeted measures on certain, for example, embargo on certain materials and technologies, freezing measures on certain designated persons, etc., etc. The US sanctions, however, are far more comprehensive. So they go back a step. In other words, they are a regression back to comprehensive sanctions. The measures include, in particular, sanctions on the energy sector, which are based on new legislative acts, in particular the Iran Sanctions Act, the ISA, adopted in 1996, which curbs international investment into Iran's energy sector. And this is not something which is reflected in the Security Council resolutions. And there is also the Comprehensive Iran Sanctions Accountability and Divestment Act of 2010, CISADA, which aims to penalize domestic and foreign companies for selling to Iran refined gas, gasoline, and related equipment. There's also a comprehensive ban on US trade and investment in Iran. So again, the point I want to make is that here there is a departure from the targeted sanctions, which was a choice of the Security Council, deliberate choice. Attempts to further the sanctions in the Council were met by opposition. There's also a vast array of financial sanctions on the banking regime, et cetera, on the currency, and I'm sure that this will be gone into later on. So it's clear that these measures go well beyond the targeted sanctions of the Security Council. And as to their objectives, it is clear that these are not the same as those of the Security Council. The objective of sanctions in the Security Council was, of course, to end the threat to international peace and security posed by Iran's uranium enrichment related nuclear program, as determined by the Security Council. And it's very clear from the resolutions that it is the Council alone competent to determine when the sanctions are to be suspended or terminated. That is to determine when Iran has fully complied with its obligations under the resolutions of the Security Council. And again, the resolutions reserve to the Council and its Sanctions Committee the sole authority to add designations to the lists of targeted persons, leaving no margin of appreciation to the member states. On the contrary, the objectives of the US sanctions clearly stated, or countermeasures, include, of course, regime change and so on and so forth. They go well beyond implementation of Council sanctions. So, are they implementation? No. Are they enforcement of the sanctions by adding new legislative measures to enforce? It's interesting that the Council stresses that nothing, that's Resolution 1929, nothing in this resolution compels states to take measures or actions exceeding the scope of this resolution, including the use of force or the threat of force. And the Council also establishes its own monitoring and reporting system. It says it shall review Iran's actions, and if it determines that Iran is not in compliance, it shall adopt further appropriate measures. So, and the Council further specifies that concrete measures on exploring an overall strategy of resolving the Iranian nuclear issue taken by states should be sought through non-forceful ways and encourages to the seeking of a negotiated solution. And the Council continues to be seized of the matter. So nowhere does it appear that individual member states have been authorized to enforce Council decisions against Iran extraterritorially or against third parties. For example, states are to adopt these measures by their nationals or on their territory or using their flag vessels or aircraft. Nor does the Council authorize an embargo at sea, as it did in regard to previous sanctions regimes. It calls on states to inspect the cargoes of Iranian state-owned aircraft and vessels only at their airports and seaports. So it's quite obvious that the Security Council resolutions do not require extraterritorial application, as did some of the earlier resolutions of the Council in other sanctions regimes. And this was debated and controversial, and some states vociferously opposed the application of sanctions extraterritorially. So in short, as I've said, they cannot be seen in the light of collective measures. And the US cannot use the justifications of Article 25 or 103 to justify the measures. So the justification that remains is as unilateral countermeasures. However, they have to meet a certain number of conditions laid down in the state responsibility articles. Some of them have been mentioned by Dr. Pereira. Who can invoke these measures? The state imposing countermeasures, firstly, must demonstrate that it is an injured state, which would allow it to take these countermeasures. And a state is considered injured and hence entitled to invoke responsibility of another state and adopt countermeasures if the obligation is owed to it individually, or in the case of a collective obligation, is owed to a group of states of which the injured state is a part. Such as, and we could give the example here, that perhaps the NPT treaty, if considered an integral or interdependent treaty, would fall into this category as a collective obligation owed to a group of states. But in this latter case, one would have to demonstrate first that there has been a breach of the obligations contained therein, which is not evident, or that it has specially affected the United States or radically affected the enjoyment of the rights or the performance of the obligations of all the other state parties. And these conditions may prove difficult to demonstrate. So in short, the legal basis for a countermeasure is not a threat to the peace or threat to national security, but a violation of international law, and the state must be an injured state within that definition. Now, under Article 48 of the ILC articles, a state which is not an injured state has a legal interest in compliance, but has no right to take countermeasures, only to invoke responsibility in order to demand cessation of the breach or reparations on behalf of the injured state. Now, there is a question that is controversial and that has been debated in the ILC, and that is whether a state which is not an injured state in that sense may take countermeasures to enforce obligations protecting general or collective interests, important for or fundamental to the international community as a whole. And this type of countermeasure, however, as I've said, is controversial, and Article 54 refers to the right of any state other than the injured state to take lawful measures, it doesn't mention countermeasures, to ensure cessation of the breach in the interest of the injured state. Now, I'm saying that this Article 54 is ambiguous and has perhaps a deliberate ambiguity, since there was so much controversy in the ILC. So it may be argued that the law of collective security has, in this particular situation of parallel imposition of collective measures, displaced the law of state responsibility. It could very well be, but that again is debated, that a state's right to adopt countermeasures terminates in situations where the Council has exercised its exclusive responsibility to determine under Chapter 7 a threat to the peace. Because there's been an argument that unilateral measures in this case would only serve to undermine the exclusive prerogative of the Security Council. Assuming that the measures can nevertheless be characterized as lawful countermeasures, they still have to comply with conditions and limitations laid down. For example, they may not be punitive, they may not cause irreparable damage, and that is important. They are supposed to be temporary measures which are reversible. They're not meant to be punitive. So one can argue or one can debate whether the measures taken in particular situations go beyond reversibility. In other words, where they cause such damage that they can no longer be reversed. Secondly, they're not to be directed against third parties, and so on, which of course the US laws can be seen to be in imposing penalties on third parties who do certain transactions with Iran. They must be proportional, commensurate with the injury suffered, and they must not depart from certain basic obligations. We know that the prohibition of the use of force, of course, applies to them, but there is also the protection of fundamental human rights, interpreted by the ILC as the non-derogable rights in the respective treaties, and of a humanitarian character, prohibiting reprisals, as well as peremptory norms of general international law. And then there are procedural requirements. They must implement dispute settlement procedures. The term good faith is applied to these dispute settlement procedures, offers to negotiate, and so on. So the question in the light of this, of this framework, if you use this framework, the question is whether these sanctions constitute comprehensive sanctions, affect Iran's economy, right to development, and so on and so forth. But as I've said, I'm only providing a grid for analysis. Now, that's not the be-all and end-all. I don't want to stop with the state responsibility articles, because these conditions, the articles on state responsibility themselves recognize that their provisions are not exhaustive. In other words, you have to also turn to general international law and to particular regimes, and that there may be also a development of the law. Now, we know that outside the framework, for example, the General Assembly has underlined in numerous resolutions that the embargo on Cuba is, of course, contrary to sovereign equality of states, non-intervention, non-interference, and so on. But quite apart from such developments, in other words, what I'm trying to say is that now you have to approach unilateral measures also in the light of what is happening in respect of collective measures, because there is a kind of feeding in, there's a loop here. And just as one argues that the states cannot escape their unilateral obligations by hiding behind the corporate veil, so they cannot hide behind the corporate veil in trying to escape, the other way around. They cannot, of course, use unilateral measures to escape the corporate veil, I'm getting all mixed up now, to escape the collective measures and all the constraints placed on collective measures. So I believe that unilateral measures should be reviewed in the light of what has been happening, and a lot has been happening in the field of collective measures. We've had challenges to such collective measures. We've had a rereading of the Charter purposes and principles. Article 1 speaks of collective security, one of the functions of the UN, but collective security has to be interpreted in the light of the concept of human security now. And the Security Council has been very aware of that in insisting in some of its resolutions that states in implementing sanctions should do that with regard to its obligations under human rights law. There is also the concept of rule of law, which has sprung up in terms of the international organizations. And so there's been a grand debate over the humanitarian fallout of comprehensive sanctions, particularly the decade-long sanctions against Iraq. And then when the Security Council was pushed to move to targeted sanctions, there's been a grand debate as to the due process rights of the individuals who have been targeted as terrorists.